The Rules Committee will come to order. We're here for consideration of a number of measures, the first of which is the Federal Communications Commission Process Reform Act of 2012, and we're very happy to welcome the distinguished chairman of the subcommittee on Communications and Technology from the Energy and Commerce Committee. But before recognizing Mr. Walden, I'd like to recognize our good friend from Grandfather Community who introduced us to some guests who are visiting us today.
Thank you, Mr. Chairman. There are two students who are representing the Graduate and Professional Student Federation from North Carolina. We have Michael Bertucci and Joellen McBride who are here, and I invited them to come over. We also have Mr. Michael Herson and Kyle Herson back there, and Kyle will be joining me on the floor in a little while to help us with our voting. So thank you very much for allowing me to recognize. Kyle's going to go with. We don't
violate the House rules at all by doing that, Kyle.
He's only helping.
Yeah, we look forward to welcoming you, Kyle, and welcome to all the rest of you. We're very happy to have you. Do any of you know where Grandfather Community is in North Carolina? That's the only question I see. Nobody knows. Once again, yes, no, I know you do, but I've yet to meet someone from North Carolina who actually knows the hometown of my friend from Grandfather Community.
Actually, Mr. Chairman, I don't encourage people to move there. We have more people than we need already, so I don't want to encourage folks to come. It's a wonderful place.
Well, since I mentioned that, I'm reminded of a story that I always like to tell of a former member of the Rules Committee who was also in the Post Office and Civil Service Committee, and he was at a hearing at the Post Office and Civil Service Committee, which no longer exists. The committee it is. He had a witness there, and he pointed to the fact, he said, I keep hearing that everybody up here in Washington, D.C. is so doggone smart. He said, I've got to tell you that, nobody in Washington, D.C. knows where Sarcoxy, Missouri is, but everybody in Sarcoxy, Missouri knows where Washington, D.C. is. And so I hope somebody knows where Grandfather Community, North Carolina is. So with that, Mr. Walden, we're happy to recognize you and happy to have the ranking member of the Subcommittee on Communications and Technology, my California colleague, Ms. Eshu, with you. And so without objection, a prepared statement that you have will appear in the record in its entirety, and we welcome your summary.
Thank you very much, Mr. Chairman. While I don't know the location of the town you referenced, I do know where
Grandfather Community.
I do know where Winston-Salem, North Carolina is, since our son is going to graduate from Wake Forest University soon, and I can stop sending economic aid to North Carolina. I want to thank you, Chairman Dreyer, for scheduling this Rules Committee hearing on a bill I introduced with Mr. Kinzinger, the FCC Process Reform Act of 2012. Now, the communications and technology sector is the most competitive, innovative, and open sector of our economy. From fiber optics to 4G wireless service, from smartphone to tablets to the connected TV, this sector has been creating new services and new devices and the high-quality jobs that come with high-tech innovation and investment. Despite a lackluster economy and the red tape coming out of Washington, D.C., wireline, wireless, and cable providers invested $66 billion in broadband infrastructure in 2010. Indeed, the United States is now leading in cutting-edge wireless technology. Communications and technology companies and the public deserve the most transparent and responsive government agency, and that's exactly what this bill is about, bringing transparency and accountability to the Federal Communications Commission. The bill is the fruit of the Energy and Commerce Committee's own open and transparent legislative process. Last May, we invited the commissioners from the FCC to testify about improving the FCC's processes, and we heard from them about the process problems that have occurred at the agency under both parties. In June, staff released a discussion draft. Then we held a hearing on the discussion draft with a diverse panel of experts representing industry and think tanks, consumer groups, academia, and the states. And in response to the views presented at the hearing, as well as additional input from stakeholders and colleagues on both sides of the aisle, we refined the draft legislation. Then in November, the Subcommittee on Communications and Technology held an open markup of the bill. And earlier this month, the committee marked up the bill with several bipartisan amendments to improve the FCC processes. In large part, the FCC Process Reform Act asks the FCC to go through a process similar to what we've gone through in crafting it, and to implement some of the reforms that the House itself adopted just last year. For example, the FCC regularly issues final decisions without giving the public an opportunity to review the text. The House of Representatives doesn't operate that way. The transition team I led after the last congressional election adopted a layover requirement to make sure that the public and members of Congress have a chance to read each bill before we vote. If we can do it, so can the FCC. The bill requires the FCC to make texts available before considering an item at a public meeting. I don't think that's asking too much. Sometimes the FCC doesn't give the public sufficient time to comment. Last October, for example, the agency introduced more than 100 new documents into the record for its universal service proceeding, and they did it in the last few days of the public comment period. They gave the public as few as 2 days to comment on thousands of pages of new data, and I don't think that's right. So this bill fixes the problem by requiring the Federal Communications Commission, an independent agency, to provide the public a minimum amount of time to review filings and comment on proposed rules. Also troubling is the way the FCC has treated the small businesses and consumers that interact with the agency on a day-to-day basis. 4,984 petitions, 3,950 applications, and more than 1,083 consumer complaints have languished at the Commission for more than 2 years. 2 years. That's far too long for a consumer to get an answer from the FCC. 2 years is a lifetime for an entrepreneur in the communications marketplace. So the bill requires the FCC to set shot clocks for decisions. Let them figure out what those should be. But then the public will know when to expect an answer. And then there's the FCC's problematic transaction review process. In recent years, the FCC has leveraged its authority to review transactions to accomplish unrelated policy goals and insulate its rulemakings from judicial review. It does through last-minute side deals with applicants that are often not disclosed until just a few days or even hours before the FCC approves the deal. Now, one problem with these so-called voluntary commitments is that they aren't so voluntary. Another potentially greater problem is the FCC has used its transaction review process to avoid good process. The APA already requires the FCC already gives the FCC the ability to accomplish its policy goals, an open and transparent rulemaking. But why go through the hassle of proposing rules and seeking public comment when a handshake will accomplish the same end? Well, the bill eliminates this end around the APA by requiring the FCC to tie any conditions it places on a transaction to transaction-specific harms and within the FCC's jurisdiction. Now, I note that the FCC Process Reform Act does not dictate the outcome of any transaction review. It does not change the public interest standard that the FCC uses to approve or deny a merger, period. If the FCC determines that a merger of two companies is against the public interest, the FCC can still deny that merger. Now, some have said we should not treat the FCC differently from other agencies. Well, the fact is the FCC is already treated differently. Unlike executive agencies, the FCC is not currently required to analyze the costs and benefits of its proposed rules. President Obama and the Jobs Council he appointed both seem to think that's a problem. The Jobs Council called on Congress last year to adopt legislation to require independent agencies, such as the FCC, to do what we do in this bill, and that's conduct a cost-benefit analysis before putting more red tape on industries. The bill does exactly that. Similarly, there have been calls from both sides of the aisle for institutional reform at the FCC. Former White House advisor Philip Weiser has said that the agency is, quote, in dire need of institutional reform, close quote. State commissions have been calling for the reform of the FCC's rulemaking processes for years, and former Commissioner Michael Copps has noted the need for a bipartisan majority of commissioners to move forward with consensus reforms. Even subcommittee ranking member, my friend Ms. Eshoo, has called for FCC-specific process reforms and her FCC Collaboration Act, which would create an APA carve-out for the FCC and the FCC alone, and I support that. I reiterate the problems at the FCC are largely institutional, not personal. In fact, Chairman Julius Genachowski has made good strides forward to improve the FCC and make its processes more transparent, and he's committed to complying with the spirit of President Obama's executive orders on regulatory reform. But the good processes should not vary from one administration to the next, from one chairman of the FCC to the next, and only legislation can lock in the process improvements we've seen so far. So these bills are supported by the overwhelming majority of the industry, including sectors that are sometimes at odds. It's a rare day when the National Association of Regulatory Utility Commissioners, joins hands with CTIA, NAB, National Cable Television Association, National Telephone Association, USTA, and others in support of the legislation, but they do so today. The American public expects and deserves a transparent and accountable federal government, no matter what administration. So I say let's start with the agency overseeing our most open and innovative companies. Let's start with the FCC, and I would urge your support of moving this bill to the floor.
Thank you very much, Mr. Walden.
Chairman, it's good to be with you and Ranking Member Slaughter and all the members of the committee. I'm here in my capacity as the Ranking Member of the Communications and Technology Subcommittee, and it's good to be with you. I commend both the chairman and my colleagues on the subcommittee for undertaking a thorough review of the FCC's and we certainly, as Democrats, support modernizing the agency's rules to respond to today's dynamic communications marketplace. But I can't support the bill, and most of the Democrats are not supporting the bill for reasons that I will state. Over the course of the past year, our subcommittee has heard from countless industry representatives, administrative law experts, and public interest advocates. Despite the feedback of a bipartisan group of administrative law experts who suggested this legislation could tie up the FCC, this is a very important point, tie up the FCC in 15 years of litigation. I don't think that's what we want the outcome of anything to be around here. We're still moving ahead today with a bill that primarily obviously does that. And there is not in the list of supporters any public interest advocates, which I think is a shortcoming in the effort. As Democrats, we've tried to be constructive throughout the process, offering an alternative approach to reform that would preserve those provisions which we agree on, while striking anything that would undermine the FCC's ability to promote openness, transparency, accountability, and competition. One example, which the chairman of the subcommittee graciously stated, is the FCC Collaboration Act, which I offered last year to improve the efficiency of the FCC's operations. The proposal is bipartisan and was supported by many of the witnesses who testified before our subcommittee, including the former Republican Commissioner Kathleen Abernathy. In fact, it's the only FCC reform proposal with equal support amongst Democrats and Republicans of the subcommittee. During markup of 3309, I offered a substitute amendment that incorporated this bipartisan proposal. The amendment also adopted a series of best practices offered by the administrative law experts to increase public participation and enhance the quality of information received by the agencies like the FCC. I think, Mr. Chairman and members of the committee, we have to ask ourselves the following. Are there specific problems that are unique to the FCC? And if so, can they be addressed with rigorous agency oversight? Earlier this month, Chairman Issa released a report that gave the FCC an A, ranking it among the best federal agencies for its management of the Freedom of Information Act and the FOIA requests. So while this may be one example, I don't think it really points to an agency that's in total disrepair. I think that 3309 will institute new burdensome regulatory requirements and fundamentally alter the agency's authority to review transactions while effectively rolling back the reforms put in place by the current FCC chairman, which again, Chairman Walden has underscored, to his credit. And those have, we are all acknowledging, have made the agency more effective, more agile, and more transparent. Now, to add insult to injury, and I think everyone needs to fully appreciate this, CBO estimates are that if enacted, 3309 would cost $26 million and require the agency to hire an additional 20 employees to handle the new rulemaking, reporting, and analysis activities required under the bill. So I think this takes us in the wrong direction, not in the right direction. If you want more regulations, if you want more burdens, if you want more costs, I guess this is the bill to support, but that's not according to the CBO's estimates. So for all of these reasons, I can't support the bill. I'm also encouraging the Rules Committee to support an amendment that I offered at the committee to bring about meaningful disclosure at the FCC regarding political advertising. My amendment is really very simple, and it adheres to the same principles that many of my colleagues have supported before. What it does is the following. If an organization buys political advertising time on cable, satellite, or broadcast television or radio, they would be required to disclose donors who give $10,000 or more to the entity requesting airtime. Current law already requires the maintenance and disclosure of political programming files for public inspection. So there isn't anything new to this. What I've added is this amount and above. We know the country is drowning in these super PACs. So under existing law, a licensee must maintain a complete record of request to purchase broadcast time regarding a political candidate or national political issue. So there are no burdens for broadcasters, for TV stations, for satellite, for cable. They have to maintain the record anyway.
Well, thank you very much for that, Ms. Eshwin. Let me just say I'm going to encourage this committee to make your amendment in order.
Terrific.
I'm going to encourage that, and I believe that they should make all of the amendments in order that have been submitted. With one exception, there's duplication. My California colleague, Ms. Waters, offered virtually identical to yours, and so I think that you, as the ranking member, should have your amendment considered there. And again, I'm going to consider, most of the amendments are offered by Democrats to address, I think, many of the concerns that you have raised. The one thing is somebody just handed me a piece of paper, put it in front of me here, that said, did you know CBO estimates that implementing the provisions of H.R. 3309 would cost $26 million over the 2013 to 2017 period and required 20 additional staff positions to handle the new rulemaking, reporting, and analysis activities required under the bill? It was almost identical to what you were just saying.
Yeah, that's from my office.
Oh, yeah, okay. Well, I don't know who it was. Somebody just put this in front of me.
Oh.
And so since somebody just put this in front of me, I guess I should...
It should have my name on it,
just...
because I have one right
Is your
here
name, did
that
you
I was
know?
going to hold up.
Did you know? It does have your name on it. So anyway. Disclosure, is that what you're saying? Yeah, there wasn't adequate disclosure on this.
Right here.
Anyway.
I was going to hold it up when I spoke.
Somebody just put it in front of me, and so I read it. Usually when things are put in front of me, I read them.
And I said it.
I don't know if you, right, no, I understand, but I just wondered, in light of this, if Mr. Walden wanted to offer any thoughts on this. Have you seen this? Or?
Well, I'm aware of the CBO estimate. I would just suggest that there is work that has to be done here to clean up this commission, the way it operates, and we can make it more transparent. Now, the interesting thing is that this is a fee-driven commission. So the cost would be put on those who are doing business before the commission, so it wouldn't be money out of the general fund. The interesting thing is a lot of the people who are doing business for the commission support the reforms that are here, so I would assume they would support funding those reforms. The long and the short of it here, though, is we need to clear up and make more transparent the operation of the Federal Communications Commission. I'll give you an example. At the end of the year, on the Universal Service Fund rulemaking, they voted on basically a press release. And then they go, the way this works, then they circulate their document among themselves on email, and then they do edits. The document came out much later, was 750 pages long. Now, I've asked for the commission to provide me with the original document that they started with and the document that became the rule, and to make that available. And the commission has been quite reluctant to do that. My point is, my dear friend here has an amendment before you. You know what that amendment says. I'll know it when I read it finally, but it's available for you and anybody else to read. And then we'll have a vote on it, and we'll debate it. What happens at the commission is they'll have an idea. They'll vote on it. And then later you'll find out what it was. I think that's a bad process. I think the text and other I think the text should be available to the public, to the press, to us, before they begin to vote. The Federal Energy Regulatory Commission, a similar independent agency, operates that way. Their rulemaking texts are available so that those who have issues can read what's going to be voted on and comment in due process. These are the kind of changes I think need to be institutionalized and would be so under this legislation. Be done so.
Thank you again, Mr. Chairman. And again, I want to emphasize that Democrats are for reforms. I mean, we've offered several of them at the committee, and I want to compliment the chairman on the process that we went through in terms of hearings. There's something that needs to be understood here, though, and that is that you can't really call something a reform if the experts say it's going to tie the agency up in litigation for up to 15 years. I mean, that's more than throwing sand in the gears. There is a body of experts that reviews what we do relative to the executive branch, to the agencies, and this is a real departure on singling out one agency rather than using a uniformity to what we do with the executive branch. So while we have some things where we agree, there is some strong disagreement on what the outcomes would be.
Well, I'm glad that we all are in favor of reform. At least we.
Well, you know, I mean, who's going to do against reform until we get into the rules?
That's one of the reasons I'm going to recommend that this committee make an order of the amendments that you have submitted and that others have submitted as well.
We appreciate
Mr.
that.
Sessions.
Can I just add, Mr. Chairman, that there are 45 public interest groups, religious organizations, including the United Church of Christ, Public Knowledge, Free Press, the Communication Workers of America, the Writers Guild of America, the National Federation of Community Broadcasters that oppose the 3309 as submitted.
Mr. Chairman, thank you very much. Anna, thank you for being here.
Thank you.
Chairman Walden, appreciate you being here. You had talked about these ideas that it would be changes to the commission. Evidently, they're answering questions that would lead to litigation because people disagree. Isn't Congress providing an answer to some of these great ideas, or what are the examples of things that would be tied up in court for 15 years?
Well, we can submit that to you for the record. I need to ask the staff. Is it called the ACUS? Is that the what? The ACUS is the one that issued that statement about
But I know you know far more than I do about this. What would be some of the ideas that would be wrapped up in litigation for 15 years?
Because it pulls out one agency to apply some rules but not to others, and those things would be litigated. I can give this to you. It represents, in their view, a heavy-handed approach to reforming by codifying many of the FCC's internal procedures into a statute. For example, the legislation essentially requires the FCC to conduct 2 rounds of notice and comment for each proceeding with a combined minimum of 60 days for comments and reply comments before the agency can move ahead to consider rules. So the 60-day minimum comment period is not subject to the good cause exception. It keeps unwinding. And at each turn, and I'll submit this for the record and put my name to it.
So remember, transparency, people wouldn't like and would litigate transparency.
Well, see, it's a mixture. People do like transparency. On the surface,
described to me?
On the surface, people always support transparency. It's how this is set up. The timing and duration of the proceedings would be left to the discretion of the FCC and the specific details of the matter of the issue. In some cases, the FCC may want to initiate a multi-round proceeding. And each step of the way, these are subject to, I think that this is a great act if it goes forward this way for lawyers. I think lawyers are really going to do well under this because of the litigation prospects.
Mr. Walden?
Well, I of course, would have a different view on that matter. First of all, there are good exception abilities for the FCC to move forward. Second, I would tell you that we drew from well-established legal sources. Administrative law professor Ronald Levin testified that the logical outgrowth test reflects existing D.C. Circuit case. The good cause exception to the notice of inquiry requirements tracks the good cause exception language of the Administrative Procedures Act. So you've got if you cut to the chase here, we've actually left the FCC with the authority to get into the minutia and the specifics. That's what we heard back from the hearing that we had in our process was, don't tie our hands with specific dates and deadlines and all. And so we don't. What we do say to the FCC is, have an internal set of rules and live by them. You decide what the duration should be to conclude your business, depending upon what it is you're working on, but have a duration, have a shot clock, and then report whether you've met your deadlines or not. We're going to tell you, you have a 40-day shot clock on this and a 60-day shot clock on that, but the industry is so vibrant and so quick that right now, as I read in my testimony, there are thousands of applications and things pending for upwards of 2 years. And you need some level of certainty. Now, we saw a commission headed by a prior chairman that ended up with four commissioners on one side and the chairman on the other on a lot of things. And a lot of things broke down during that period. You don't have that happening right now under this chairman. Well, you only have 3 commissioners. But the second piece of it is it could happen again. I think we should lead with this agency, making the kinds of improvements that are supported by the, your public utility commissions. The National Utility Regulatory Commission supports a lot of what we're doing here. And so we've tried to find a good, solid balance to open up this process, to shine some light in, to hold it accountable. We've tried to deal with the issues that Ms. Eshu has raised in terms of litigation. The bill defines economically significant and program activity. Those were 2 things that people were concerned about. That's based on the $100 million threshold that's been in executive orders of the President of the United States, every President of the United States since Ronald Reagan. This is a well-established definition. And the bill is designed actually to reduce litigation. Courts regularly defer to the FCC when it interprets the Communications Act. It's known as the Chevron defense. Now, I'm not an attorney, but we've worked with attorneys who have said this is the way you get around the problems that have been identified. So we've tried to listen and learn, and we've modified the bill to make it work. And so I don't buy into this notion that's going to tie anything. I don't see how having transparency and accountability, having an agency actually produce for the public and the people it's regulating its text of what it's going to vote on in advance is a bad thing. That's what we're requiring here. Put it out there. Let people see. Don't hide this stuff in the closet. Don't do big data dumps at the last minute. Don't write rules behind the scenes and then publish them only to have those affected by them not be able to know what's coming until they're there. I don't think that's the kind of process we need in this town. I think it's what makes Americans pretty upset with what happens in their government in Washington. So I think we found the right balance.
Well, I think the argument that Ann is making in here would be a good reason why we should have done the Obamacare bill, too. Full of litigation is a good reason not to do it. I yield back my time.
Thank you, Mr. Chairman, and thank you both for being here this afternoon. Ms. Eshu, I appreciate your amendment very much, and it delights me that it would be made in order. I'm happy for that. I would like to ask unanimous consent to put the administration's policy on the record.
Without objection, the statement of administration policy will appear on the record.
The administration opposes the passage of H.R. 3390. It would limit the ability of the FCC to exercise its statutory duty to protect the public interest in its review of transactions affecting the vital communications industry. It would, in effect, create a separate Administrative Procedure Act, APA, for the FCC for more than 60 years. Well, I'm not going to read all of this. I think we can all read it for ourselves. But I would like to do the concluding sentence. H.R. 3309 would limit the ability of the FCC and the Justice Department to work together on telecommunication matters to protect consumers, to promote competition, to increase innovation, to ensure access to more choices, lower rates and prices, and better products, and is evidenced by Executive Orders 13563, 13579. The administration is committed to ensuring that the decisions of all federal agencies are open, transparent, well-founded, and protective of the public interest. H.R. 3309 does not further those goals. And I think I understand this issue pretty well, Mr. Chairman. I have no questions.
Thank you, Mr. Chairman. I don't have any questions. I just want to thank Chairman Walden for his good work and appreciate both his and Ms. Eshu in being here.
I want to thank you both for being here. I strongly support the issue amendment, and I have no questions.
Thank you, Mr. Chairman. I appreciate the ranking member reading that statement of administrative policy. I'm going to have to read the whole thing in its entirety, but it seemed like that last line said, don't you guys on Capitol Hill worry about a thing. We're on the case down here when it comes to full disclosure and watching after consumers, and we'll take care of it. I'm glad you're on the case, too, Mr. Walden. I appreciate your being here. Ms. Eshu, I love openness in this process. I go home, I brag all the time that we've let more amendments through in this Rules Committee than any of the last Republican or Democratic Rules Committees in the last decade. And so it always concerns me when we look at something that's duplicative and say that we can't make that in order. And I know in this case, when there were two ideas that were similar, it was your amendment that we decided, or that the chairman is inclined to make in order. Could you explain to me in a little more detail?
Yes, I'd be glad to. Thank you for your nice comments, and to all of the committee as well. It's I believe it's entitled the FCC Collaboration Act, and I think this is the second Congress that I've introduced the bill, and it's been bipartisan from the beginning. The way the FCC has to operate today, members of that commission, which is a very small one, cannot actually sit down and have a conversation with one another. They're prohibited from doing that. And we've had hearing after hearing where they have pointed out, both Republican commissioners and Democratic commissioners, that if they indeed could have collaborated, that they believe that many, or at least some of their outcomes would have been enhanced by that collaboration. And so they have supported it. The chairman of the commission supports it. Republicans and Democrats on the committee support it. And I think that we all know that today's telecommunications marketplace and technology have become far more complex, and it does call for people talking to each other. So it's a rather simple but I think important thing that should be undertaken, and I trust that the Congress will pass it. Thank you for asking about it.
Mr. Walden, I see there are several amendments that were submitted that dealt with disclosure of folks involved in political programming.
Mm-hmm.
Were those considered in the committee as well, or are we seeing them here for the first time?
At least one of them was considered in the committee. I haven't had a chance to read all of them in the fine detail as submitted yet, but I believe Ms. Eshu's amendment, I assume it's the same one as submitted and was roundly defeated in full committee. And I understand the argument that she's making, and disclosure is a good thing. I'm just not convinced that we have the right letters. It should be FEC, Federal Election Commission, where donors should be disclosed and expenditure should be reported, not necessarily put on the broadcasters as part of what they're required to do.
Ms. Eshu, in my part of the world, much of the national political programming is one-sided down in the Deep South. We have a great commonality of interest down there, and I know in your definition of what would be disclosed, it was only those issues of national importance. Now, I'm one of those who believes that our governor's election is one that's of national importance. We're the finest state in the union, and it would behoove the other 49 to know what we're doing in that respect. But you specifically left out all of those issues that don't rise to the national level. Is national importance defined somewhere else in the code, or is that something that's going to be litigated?
This applies. This keeps in place and does not change the federal requirement that is the law of the land today, and that is that broadcasters, satellite, cable, TV, all are required to have files, and people are to report. The only change that I'm making in that, and I'm not a state legislator, so what I'm doing is out of a federal legislature, is to add the requirement of those that are purchasing. This is not a burden of the broadcasters or anyone else. They keep the file, but this is for anyone that is spending $10,000 or more, that there be disclosure and transparency. That's the only change to it.
The national importance is already defined in the in the code today?
Well, yes, it is. It's by its very existence that these files are there. They may be dormant. Maybe most people aren't aware of them, but that is the law.
Well, then I may be one of those that's not aware of them. This is saying, because I love data dumps as much as anybody. You never know what you're going to learn when things are out there. That communicating that political programming is defined by anything that communicates a message relating to any political matter of national importance. Everything today that communicates a political matter of national importance is already documented in a file.
Have you ever looked at the file?
I haven't. That's what I'm saying. I'm here to be educated.
He has, because he's a broadcaster.
Mr. Ward.
This was designed. I think. Were you asking me the question?
I am. Unless you'd rather Mr. Walden answer, I'm just here to learn.
I think we both will.
Just here to learn.
We both will. This is directed at the tsunami of money that is cascading over our entire political system in the country. So it requires disclosure of the names above $10,000. That's all it does. Otherwise, the file is there, it's existed, it is a national law, and if there's anything that I think, at least in my view, and I think for my constituents and many people across the country, this is not only of national significance, I think this goes right to the heart of democracy.
Well, I guess, and I don't want to disclose my shortcomings here in the public hearing, but I have donors who contribute $10,000.
This is when they go to buy the time, they disclose the names.
If I might, if this, and I'm trying to get a copy of the actual amendment. Unfortunately,
I have a copy.
Maybe I can. I would just point out, if this is the same language as was before the committee, is that correct? Small modifications, every word matters, so.
Because I guess the core of my confusion is, you're talking, Ms. Eshoo, about files that already exist.
I'm talking about the law that already exists and the requirement that is a part of it. And what the addition is.
I'm a purchaser of political programming, and I have donors $10,000 or more, but I'm unaware of my contributing to a file in Washington. Perhaps they're keeping a file.
No, actually, it's.
You don't. This is not about candidates. This is about committees requesting to buy time.
Well,
they would be required to place that if it is $10,000 or more. So anything under that, there would not be the disclosure. But $10,000 or more, the names of those that are paying for that advertising would be part of that file that is kept, so that there is disclosure and transparency for the voting public.
Well, let me tell you how it works today, because my wife and I were small market radio owners for 22 years. So we kept those files, and it's not just the political purchases that you have to keep in there. There's a whole range of other things, quarterly issue reports, there are employment reports, contracts you enter into, and the FCC already specifies literally the order in which they appear in the file, and you can be fined thousands of dollars if you have the file folders out of order. So they come in, they inspect, I've been there when that's happened, and they go through your public file. That public file is available and open to the public during your regular business hours. And you make it available. Anybody comes in the door, and believe me, we've had candidates come through or their representatives and say, I want to know, if my opponent's spending any money here.
I've gotten that file. That's the file that I throw it out. Okay, the file.
And you're required to retain it for 2 years. And generally what that shows is inquiries of time. So you call my radio station, Mr. Whittle, which you could have done you still could if I owned it, and I would be happy to sell you time. I don't know what good it would do in South Carolina unless the heaviside layer came down and our AM dropped a signal in there, but Georgia too. I know, but he wants to. So here's what happens. You make an inquiry. Now you might be making an inquiry actually of my representative, who would be perhaps a regional advertising firm or a regional rep. And so they got them all the time. I mean, you'd have a big buy, and you'd have a rep that would rep a dozen or 20 or 40 stations, not mine necessarily. Mine might be a part of that. and they say, okay, I need your rate card for, I'm going to make a political buy. So they get that. Now, so there, somewhere in here, then that information would come to the station. Right now, it's just the name of the entity and who's the treasurer or whatever. Then all the contribution information is kept at the state level at the Secretary of State's office, or in our case, at the Federal Election Commission. That's where the donor information is, right? We've never had to keep that as broadcasters. What we keep is the name of the committee. And you want to go figure out who's behind the committee, you go over to that reporting agency, which is the Federal Elections Commission or the Secretary of State or whomever. Now, what makes this a little problematic is that the Commission is being told to revise its rules to require that new information be put in there that identifies a certification that identifies any donors that have contributed a total of $10,000 or more to such entity in an election reporting cycle. Now, it doesn't say this reporting cycle, it doesn't say last reporting cycle, it just says an election cycle. So it could be any time. I don't know how many decades back that might be, but in theory it can be, the wording is an election reporting cycle.
The election and reporting cycle is defined as the previous 2 years.
Well, I haven't
That's
got
already
that.
in the law, so.
Well, it doesn't say that here. Right there.
She does there is on page 2 a reporting cycle definition, because I had to get out my calendar and go through preceding and subsequent, and there was some calendaring
Our election, the
issues.
federal election cycles, as we know, are 2 years.
2 year cycles.
2 year cycles. So we keep the entirety of the law in place, and what this amendment does is to add the responsibility of the buyer of time to place in the file any buys $10,000 or more, who the people are that are buying that, so that the voters will know. It's that simple.
What I didn't see defined in there, though, was donor. Is donor a term of art that we're borrowing from the
Contributors.
from the FEC? I just think, you know,
I'm not looking at the exact language in the amendment, but very practically speaking, this is what this is directed toward, so that there will not be secret donors, secret money, secret amounts, secret everything. We're not a plutocracy, we're a democracy. So that's why I'm offering the amendment to be added to the law that's already on the books. It's as simple as that.
And I would say that's why I asked if this was the same amendment as considered in committee, because in committee the wording was such that it was donors from the prior 2 years. Which I said, well, then you just create a new entity, has no prior donors, and you can drive a truck through it. So
Which I think was, if I might,
they
miswritten, because what point would that make? I mean, it just doesn't help the voter after an election has already gone down to get the information.
Right.
That's not going to make,
Which
I don't
is
think
why
it's
that
going to make
amendment
anyone
had
else
a
feel
problem.
good.
Now, the other thing that our council would indicate is that this could trigger reporting of information of contributors to a nonprofit, the data for which may not be publicly available. So if you gave to a nonprofit that was a contributor to some entity, we may. Now you're talking about how you restrict speech. I think that gets interesting.
well, I know everybody's always focused on super PACs. My concern would be that instead of having contributions to super PACs, we just begin selling $50,000 a year memberships to super PACs that come free with a membership pin and a coffee mug. And we'd be outside of our donor.
The whole thing is an ugly subject.
It is, and I just didn't know if this was intended to get all the way down the weeds and put a stop to that practice altogether, if this was just making that larger
The
point.
Supreme Court has spoken, and I think, Mr. Woodall, that it's a terrible decision. That's my view. It may not be the view that others hold. But there has been, or there was, consensus in both parties that regardless of what the Supreme Court did in Citizens United, that disclosure and transparency, even when you read the court case, the justices all wrote about the importance of that. So that's what's at the heart of the amendment, is transparency and disclosure, for the voters to know who, above that amount and above, who has bought the time, so that people know. It doesn't limit their buying time. They're going to buy as much as they want, as much as they raise. All it says is this is
And
who
see,
has
our
come
point
up
would
with
be
the
Sure, that's
money.
not just the heart of the amendment, that's the heart of your entire bill. Mr.
No, actually,
Sure.
our bill is dealing with trying to get the FCC to reform
Yeah.
its process.
I mean, disclosure and
This is being-
transparency.
Yeah, it
with the
is.
FCC.
Amendment.
My point is, this is being tagged on to a structural reform of the FCC as a way, it's a vehicle to which we can have this argument, but this is the wrong place to get into the argument about disclosure. I think that belongs best at the FEC, Federal Elections Commission, and I think more transparency there makes sense on who, we ought to report. These groups ought to report. Who are they? And they ought to be on the right sequence of timing. That's another issue on some of the reporting, is it's sort of an off timing sequence. And so I think the donors, the expenditure should be reported. I just think it should be over at the FEC and not put the burden in effect on the broadcasters by requiring that they have this before they can quote time sales. It's not their job.
I think if I might add something, Mr. Chairman, this is not, if this is going to be marketed, and it probably would be smart for anyone that opposes this amendment to market it as being something burdensome. Everybody gets all up in arms when they say, oh my God, this is going to be burdensome to broadcasters, to cable, to satellite, to the television stations. It's not. It's what they already have to have a file for. The responsibility comes on the part of, the way the amendment is written, the responsibility is carried by those that are buying the time and place that information in the record. So it's the opposite.
As a final question, just because
Yes.
I have smart folks here who will explain things to me. Of course, the FEC makes their website very easy for me to navigate, find that information. Does the FCC have a similar mechanism for me to go into these files from back home, or do I actually have to
No,
walk
it's
into
not.
every broadcaster's office to access this
No, I
information?
think you'd have a hard time finding information.
All right. I thank you both, and Mr. Chairman.
Which
Thank
is
you.
another reason why it's best belongs at the FEC, because then you can rapidly go to that online filing system that already exists today, once you know the committee name.
Let me just
and look
say, I
up
hope
who
very
they
much
are.
that this committee will comply with my request to make this amendment order, so we'll be able to continue this discussion on the House floor. Mr. Hastings.
Thank you, Mr. Chairman. I'd urge my friend from Georgia to know that the day somebody walks into your local television structure and buys $500,000 worth of advertising is the day that you will want every agency that could learn where that came from in play. FEC, FCC, RRREE,
The whole alphabet.
everybody.
If the gentleman would yield,
Sure, I yield.
my hope is that I can legislate from the head rather than from the heart, because I'm certain when that circumstance befalls me, I will not be thinking clearly at that
Right,
time.
but head and heart would be involved right away trying to figure out where it came from, I promise you. Mr. Walden.
Yes, sir.
Sometime back, January to be precise, I authored a letter that was supported by a significant number of our colleagues, crying out for understanding with reference to the matter that you have referenced, and that is the universal lifeline. And you were one, along with Mr. Waxton, Mr. Upton, and Ms. Eshue, that letter was directed to. I'm not quarreling about it. I just simply would like to know what your position is with reference to universal lifeline and what the implications.
The lifeline link-up
Yeah.
issues?
Right.
Is that what you're talking
the
about?
implications are any of this particular legislation?
Well, I would tell you this, that as it was, to the extent that the Universal Service Fund reforms were part of an order that was promulgated by the Commission this last year and into this year, the extent to which the text of that would have been available before they voted on it, you might have a clear understanding. Now, Lifeline Link-Up had its own set of issues that, frankly, there was some abuse going on, and the FCC did engage in that and make some, I think, positive steps to restore the program to its intent and rid it of the abuse that, frankly, was identified by the Joint Board probably 3 years ago now, where there were some manipulators out there who were doing bad things with ratepayer money. And finally, the FCC stepped up and took action.
That said,
Yeah.
then the question that I had to you was, do you support the Lifeline program, and does this legislation have any implication that strengthens it or weakens it?
I don't think anything in here would affect the Lifeline link-up at all. Because again, this is about asking the FCC to set procedures and protocols on how it manages its business going forward.
All right. Then I gather then the easier thing for me to say is that I thought that the FCC chairman, Mr. Janikowski,
Yes,
and
sir.
the group did do some things that were helpful in the area of providing service for economically disadvantaged citizens around the country.
Right.
Going to Mr. Sessions' question that was put to you regarding the potential for litigation. Clearly, there will be litigation because there are some novel ideas that have been put forward in the legislation as it is presently constituted. And always, the interested stakeholders step up, and when the FCC makes a cost-benefit analysis of, for example, which you and I know are hard to quantify, then you can reasonably expect there's going to be litigation. When you get terms of art, yes.
But, if I could, it's no different than what the President has directed non-independent agencies to do. His own executive order directs them to do cost-benefit analysis on their rulemaking.
That, too, allows for substantial litigation. And, we're in a litigious society. But let me give you just some of the terms. Burden on industry, actual consumer harm, specific market failure. I'll bet you those are going to be litigated. Now, whether it's going to be 10 years, 15 years, 1 year, but though they present novel legal issues. And that's why you have lawyers that are able to look at those kinds of things, and the likelihood of litigation is very strong. Your staff just gave you something. Tell me what he said.
It talks about how these rules will be done, and it really, certainly everything can be litigated. I'm not a lawyer, you are, and you know the law. But our belief is that in the case of adoption, what we say here is in the case of adoption of a rule or the amendment of an existing rule that may have an economically significant impact, the order contains, 1, an identification analysis of the specific market failure. They have to do that today, and some agencies do. Actual consumer harm, they're supposed to find the harms. Burden of existing regulation or failure of public institution that warrants the adoption or amendment. And 2, a reasoned determination that the benefits of the adopted rule or the amendment of an existing rule justify its cost, recognizing that some benefits and costs are difficult to quantify. We say that. Taking into account alternative forms of regulation and the need to tailor regulation to impose the least burden on society consistent with obtaining regulatory objectives. So we try to give them language here, but in essence, I think an agency should go out and first determine, is there a harm here that we need to solve with a rule?
Right.
I mean, we do that all across the rest of the agencies, do that. The President and the Jobs Council he put together said, do this. This is important. But because the FCC is one of these independent agencies, he's not allowed to put his executive order in force there. That's the only difference here that we're speaking of. These are common practices, or should be.
I'll stop by saying that when you come up with unique process requirements, you can reasonably expect that there's going to be confusion, real or imagined.
Well,
and in that light, I was supporting the notion, not quarreling with it as a fact, that there will be substantial litigation. As to how protracted it will be, the simple fact is it will. But that's true, as you point out, of other agencies and other regulatory processes.
If I might, in fact, the FCC doesn't have a very good track record going to court when they are litigated, in part because of the bad processes they frequently used in making their decisions.
Okay.
So they would make a decision and then they'd build their record. Unlike FERC that makes the record and then makes its decision, they don't get thrown out or overturned.
You also know that the FCC has a sunshine provision that causes them to do some of the things that you talked about, to be creative, because two of them can't meet.
Two of them.
Yeah, well,
Three
it take, yeah.
Majority can't.
But you understand what I mean.
Oh, sure.
Ms. Escher, you were about to comment.
Yes, I just want to make 3 points. Thank you for raising the Universal Service Fund. That was overhauled. It needed to be. But at its core, as you mentioned, that was meant to help poorer people in our country. And I think that the chairman and I have consensus here. The Chairman Janikowski did an excellent job, and the commission did a very good job on that. Because there were some abuses, and we can't afford those abuses. They cost dollars. So I think that that's been well done, and I think the people of the country are going to be well served by it. Number 2, I think that that the legislation creates new grounds for judicial review and opportunities to second-guess agency cost-benefit reviews. So while we're talking about reforms, we're at as many times as we mention the word reform, there's a door that's flung open for an opportunity for litigation. And so I really believe that congressional oversight is the most effective method to impose FCC reform. And I think that's where we should keep our eyes.
Thank you, Mr. Chairman.
I thank you for your observations. Thank you, Mr. Chairman, for your legislative hospitality, and I thank you for your intention to support the amendment.
Please come forward without objection to the spirit statement you have before the record in its entirety. Welcome to summer. Let me begin by saying to both Mr. Diaz-Balart and Ms. Waters that I'm at this juncture going to recommend to the committee that your amendments be made in order, with the exception of the amendment that is duplicative with the amendment that Ms. Escher was offering. There's this is the disclosure. You have 3 amendments that you're proposing, and I'm going to propose that 2 of those 3 amendments be made. And so let me please, Mr. Diaz-Balart, in light of the fact that your amendment, I hope this committee will make it in order. I'm going to ask them to. I'm willing to. You're certainly one of them.
Mr. Chairman, it's a common sense amendment. It shouldn't be very controversial, and I would appreciate that. Then I got the hint, so I will be leaving. Thank you.
Waters?
Thank you very much.
Again, I'm going to make this recommendation on your amendment. Just if there are any questions, please.
Thank you very much, Mr. Chairman. I'm very appreciative for that. I do want to make some clarification about the SU amendment as opposed to mine.
Right.
My contributions have to do with companies that are seeking a merger, who give money to nonprofits to come in and talk about how great they are. As you know, I was very much involved in the Comcast-NBC Universal merger. And one of the things that happened was a lot of civil rights organizations, nonprofits, et cetera, who had been the beneficiaries of contributions, and maybe worthwhile contributions and worthwhile work that had been done maybe over a period of time or just when the merger was before us, were used as examples of support to the mergers, and I think we have to stop that. Yes.
Let me just say, I recognize that her amendment would include that.
Okay.
And so that's one of the things that we try to do here is if there is overlap, and she's the ranking member of the subcommittee.
Yes.
You requested 3 amendments, and so 2 of your 3 amendments we are looking, I'm going to encourage the committee to make them in order. So I hope very much that we will be able to do that. Are there any questions of the witnesses, Mr. Sessions? No. Mr. McGovern?
No, I just want to straighten out this issue of duplication or not. I mean, my understanding is that your amendment does something a little bit different.
Yes.
I mean, and the chairman just said that.
If the gentleman would yield,
Yes.
I thank my friend for yielding. Let me just say that the amendment that Ms. Eschu is offering would cover the issue that Ms. Waters is addressing.
Right.
In that it requires for this full disclosure that we were discussing, and that's an issue that, assuming we make the amendment that has been proposed by the ranking member of the subcommittee, Ms. Eschu, in order, it would cover those.
Is that your understanding, Ms. Waters?
With all due respect, and I appreciate Mr. Dreyer is not only recommending that my amendments be made in order, but it is a bit different.
Right.
I think Ms. Eshu's has to do with political contributions. Mine is about contributions during the merger request.
Your amendment is about conflicts of interest by people advocating that the FCC rule one way or another. One way or the other. The Eshu amendment is about disclosing political contributions.
That's right. That's right. It's a little bit different, Mr. Dwyer.
Let me just say that we proceeded with this based on the summary that we've received from the committee. And obviously, there is going to be a way, with the Eshu amendment, to be able to take this on. And what I am going to recommend to the committee is that in light of the fact that there are 3 amendments that you have proposed, and as you know, I turn myself inside out to regularly make Waters amendments in order. And I just think that at this juncture, this is what I'm going to be proposing to the committee.
Okay, I appreciate your help.
Let's see if there are any other. Mr. McGovern, any further questions? Mr. Woodall, Mr. Hastings, Mr. Scott, Mr. Polis, Mr. Webster. Thanks to both of you for being here.
All right.
And that will conclude the hearing portion for consideration of this measure. Now we're going to proceed to an original jurisdiction markup of H.R. 2309, the Postal Reform Act of 2011. And the chair reminds members that the purpose of this markup is only to consider matters within the Rules Committee's jurisdiction. Let me underscore that again before anyone proposes any amendments for us to consider. I'd just like to say that we are entertaining amendments that only consider matters within the jurisdiction of the Rules Committee, and that all members will obviously have an opportunity to address any matter that is beyond the jurisdiction of the Rules Committee when we look at the broader bill before it is considered on the House floor, we assume sometime in the next couple of months. So let me ask the gentleman from Dallas to offer a motion.
Mr. Chairman, I move that committee report the bill H.R. 2309 with an amendment in the nature of a substitute consisting of the text of the bill as reported by the Committee on Oversight and Government Reform.
Without objection, the amendment, the nature of a substitute, is considered as read, and the base text for purpose of further amendment. The chair recognizes himself for the purpose of offering an amendment. Without objection, the amendment is considered as having been read, and the chair will briefly explain the amendment. This amendment modifies the expedited procedures contained in the bill. The original text was based on the expedited procedures contained in the base realignment and closure BRAC process, which is outdated and contains a unified procedure for both the House and the Senate. Due to the differences in process between the two chambers, the amendment bifurcates the expedited procedures to reflect modern practice. As is custom, the language concerning Senate procedure is intended as a placeholder, and the amendment also strikes another set of expedited procedures that we believe to be unnecessary. And I'd like to recognize the distinguished ranking member if you'd like to offer a comment on that. I was just told by Adam that you want to offer a comment.
Thank you very much, Mr. Chair. The post office is probably one of the most important institutions in citizens' lives. And I want to object to the whole legislative process. We agree that the billion-dollar crisis that's facing the U.S. Postal Service must be resolved swiftly, but also responsibly on behalf of the American taxpayer. But this should be accomplished by simply fixing the flawed requirements that the post office overinvest in the pension system. In other words, Congress created this problem. Congress can fix this problem. What we're considering today, I don't believe is a responsible solution. It's an opportunistic attack on a constitutional agency in crisis, and one that continues and needs to continue to serve a vital function. Postal Service workers deliver the life-saving medicines to the sick in rural areas. They provide invaluable support to small businesses by delivering products throughout the week and on Saturdays. Millions of Americans rely on the Postal Service to pay their bills and stay in touch with their loved ones, and for many it remains an important lifeline to the outside world, which I have seen personally in Rochester. In addition to the impact on the customers, today's proposal is going to destroy thousands of middle-class jobs by shuttering countless post office locations without any congressional oversight. So instead of dismantling an agency that's as old as our nation itself, we should take a responsible approach to post office reform, and one that saves the middle-class jobs while helping the post office retool for another generation of service. It should not be difficult. We created the problem. We can fix it.
Well, thanks very much to my friend from Rochester, and I appreciate the comments. Is there any further discussion on the amendment, on my amendment? Yes, I'm happy to recognize the gentleman from Worcester, Mr. McGovern.
If I'm understanding your amendment correctly, it includes provisions that go beyond just the Rules Committee. You have Ways and Means and
No. The amendment that I have offered simply addresses the BRAC issue, which is a House procedure. If you'll recall, when we established the Base Realignment and Closure Commission, that was put into place through this committee, and then so expedited procedures is really what we're addressing here, Mr. McGovern.
Well,
so are you
the substitute that you're offering, the base text?
I'm sorry.
Doesn't it also?
Yeah, they were added by the Government Reform Committee, and what we're addressing is only the matters that specifically relate to the House Rules Committee, and that is our jurisdiction over the procedure that established, it's similar, as I said, to the Base Realignment and Closure Commission and expedited procedures. So if there any further discussion on the amendment, if not, without objection, the previous question is ordered, and the amendment and the, excuse me? Oh, I'm sorry. I'm so sorry, Mr. Polis. Please accept my apology for not recognizing.
Sorry, Mr. Chairman. Although, just to be clear, this is the after discussion of the manager's amendment. Do we then go to discuss it on the underlying bill?
Yeah, we're going to proceed to other amendments.
I just wanted to make sure there was the opportunity for discussion.
That's why, without objection, the previous question is ordered on the amendment, and the question occurs on adopting the amendment. All those in favor say aye. Those opposed, no. Pin the chair. The ayes have it. The ayes have it, and the amendment is agreed to. Are there further amendments or discussion? Mr. McGovern.
I have an amendment to the rule. I have an amendment to the, Mr. Chairman. The amendment that I'm proposing would require the United States Postal Service to provide greater transparency in their mail processing facility closure procedures. The United States Postal Service would have to follow the same guidelines and stipulations for closing a mail processing facility as they do for the closure of a post office. Currently, there are no specific or public guidelines that allow the public to understand why the USPS has decided to close a mail processing facility. Importantly, this would also allow decisions already made regarding the closure of mail processing facilities a chance to be reconsidered through an appeals process. And the Rules Committee can, if it decides to, make this amendment in order. Nothing that prevents us from doing it.
Let me just say that I think the gentleman offers a very interesting proposal, and it's something that obviously, in light of the fact that the gentleman is proposing that here in the original jurisdiction markup, it doesn't fall within the jurisdiction of this hearing, but I will say that the proposal is one that I think is very worthy of considering when we proceed with consideration of the overall bill itself and take it to the House floor.
But there's nothing that would prevent us from doing it here.
Other than the fact that the amendment that the gentleman offers is not germane to the jurisdiction that we have here in the Rules Committee.
Neither is the substitute.
Yeah. Okay. So the substitute that I have offered is the mechanism for us to get to the provision that was offered by the Government Reform and Oversight Committee. So what I'm saying is that I'm very willing to entertain the idea of the gentleman's motion possibly being considered when we proceed with debate on this measure and move, we hope in the next several weeks or months, this provision to the House floor. And so I'm saying that it's not germane to the Rules Committee's jurisdiction on this. So we're happy to have a vote on it.
I appreciate a vote.
Okay. Those in favor of the McGovern amendment will say aye.
Aye.
Those opposed, no. No. And pin the chair. The noes have it. The clerk will call the roll.
Mr. Sessions?
No.
Mr. Sessions votes no. Ms. Fox?
No.
Ms. Fox votes no. Mr. Bishop? Mr. Woodall? No. Mr. Woodall votes no. Mr. Nugent? Mr. Scott? No. Mr. Scott votes no. Mr. Webster? Mr. Webster votes no. Ms. Slaughter?
Aye.
Ms. Slaughter votes aye. Mr. McGovern?
Aye.
Mr. McGovern votes aye. Mr. Hastings?
Aye.
Mr. Hastings votes aye. Mr. Polis?
Aye.
Mr. Polis votes aye. Mr. Chairman.
I vote no, and Mr. Clerk, if you could report the total.
4 yea, 6 nay.
And the amendment is not agreed to. The question now occurs on the motion of the gentleman from Texas to report the bill with the amendment in the nature of a substitute as amended. All those in favor will say, oh, Mr. Polis has an amendment? I'm sorry.
So this is for discussion on the underlying the bill.
Oh, okay, you all have, sure.
Yeah.
I'm sorry.
I didn't.
So I was just entertaining other amendments.
Okay. Well, thank you. No, I think that, and I know our jurisdiction is frustratingly small on this particular bill. But looking at this bill, it doesn't seem to me it addresses the main issue that I've always had about the Postal Service. I can't figure out why the government is in the parcel delivery business. I mean, of all businesses to be in, why do we own a company that competes with UPS and FedEx? It seems to me that the Postal Service, it shouldn't be a company that's owned by the government. Why not have, if there's some residual value there, it seems like it should be sold and can compete with UPS and FedEx. And I'm again, while I looked at a bunch of possibilities, but those amendments aren't under our committee, but I look forward to working for something on the floor to try to, rather than just bail out the Postal Service like this bill does, tries to say, why is the government in this business? I mean, it might as well be, in the welding business or in the manufacturing business, or I mean, we have UPS and FedEx, and USPS would be another company, so there'd be three. It wouldn't even be a monopoly. There'd be healthy competition. But currently, it really restricts competition to have this participant in the marketplace that is owned by the government. So I hope to be able to work outside of this committee on the floor on something along those lines.
Well, it will be within this committee, because it'll be this committee that obviously is going to be entertaining the notion.
That's correct, before it gets to the floor, exactly. So, again, but in the original jurisdiction area of this committee, versus the rules of the House, there's not much that can be done about that. But I do think, can the Postal Service, as a government-run company, be bailed out and continue for a little bit here and there? It can. But I think it would be much better for the employees of the Postal Service and for competition if we can find a way to really make sure that it's a viable business going forward. And I hope that this Congress can take that up, and I'll yield back.
Mr. Hastings.
Mr. Chairman, I just had a question, and that is whether or not the construct of this measure offers two new oversight agencies, as it were, that would have unlimited power to exercise the prerogative of closing facilities.
Yeah, I can't answer that.
All right. Well, we'll get back to it.
Obviously, the process is going on right now, and again,
I understand.
we're covering here our jurisdiction, and so
my overall concern, different than Mr. Polis's, is that a lot of people are going to lose their jobs, and in an environment where a lot of people already are without the ability to work. And so I'm hopeful that when we are closing facilities, that we will take into consideration the jobs aspect, and that doubles with minorities, because services like this are places where a lot of minorities do work and have worked, and that also goes double in our society. These persons are the persons who wind up having difficulty getting jobs. So anyway, that's my 2 cents worth.
Thank you very much for that. Question now occurs on the motion of the gentleman from Texas to report the bill with the amendment in the nature of a substitute as amended. All those in favor say aye. Those opposed, no. In the chair, the ayes have it. The ayes have it. The motion is agreed to. And let me say that the minority's right to submit views, of course, will be preserved on this issue. Now we want to proceed to an original jurisdiction markup of a committee resolution relating to the retirement of our parliamentarian, with whom we work very closely on a wide range of issues. Without objection, the chair would like to proceed to this measure. As you all know, this week is actually the last week for Mr. Sullivan's service, and the chair puts before the committee a resolution thanking Mr. Sullivan for his service to the committee, the House, and the nation. And I'd like to read the resolution that we've put forward. A resolution expressing the gratitude of the Committee on Rules to the Honorable John V. Sullivan, the fourth parliamentarian of the House of Representatives, on the occasion of his retirement for his service to our committee, the nation, the House, and the nation. Whereas the Honorable John V. Sullivan has been a committed government servant for over 40 years and worked in the House of Representatives for 27 years, whereas Mr. Sullivan was appointed to the office of the parliamentarian in 1987, and over the ensuing 25 years has served under 6 successive speakers, the past 8 years as parliamentarian of the House of Representatives, under the appointments of 3 successive speakers, whereas Mr. Sullivan has displayed extraordinary rigor in the application of pertinent precedent to every parliamentary question and provided sage counsel and advice in matters critical to the institution, whereas the Committee on Rules constantly relies on the advice, counsel, and expertise of Mr. Sullivan to meet the committee's obligations to the House, whereas Mr. Sullivan has cultivated and led a team of dedicated and nonpartisan deputies, assistants, and clerks committed to ensuring that the decisions of the chair and the operation of the rostrum are regarded by all as fair, accurate, and professional, whereas Mr. Sullivan has served the House during a period of ongoing transition with shifting majorities and has done so to the same standard of nonpartisan excellence expected from the parliamentarian, whereas Mr. Sullivan participated in numerous programs of the House Democracy Partnership, providing advice and counsel to legislators from new and re-emerging democracies around the globe as they work to strengthen their legislative institutions, reform their rules of procedure, and amend their constitutions, whereas Mr. Sullivan has endeavored to update the practices and procedures of the House to reflect development in technology while remaining faithful to the institution's constitutional underpinnings, and whereas Mr. Sullivan has informed the Speaker that he will be beginning a well-deserved retirement on the last day of March 2012, now therefore be it resolved that the Committee on Rules, on behalf of the committee and the House, expresses the profound gratitude to the Honorable John V. Sullivan for his exemplary record of service and his steady, impartial advice and guidance as the parliamentarian of the House of Representatives, and the clerk of the committee is hereby directed to prepare this resolution in a manner suitable for presentation to Mr. Sullivan. Is there any discussion on the resolution? Ms. Slaughter? Mr. McGovern.
I just want to thank the chairman for doing this. Mr. Sullivan is not only, as you know, an expert on the rules, but he's a man of impeccable integrity, and this is a fitting tribute. Thank you.
Well, thank you very much.
Echo the sentiments
Thank you very much, and I
John's
suspect
the guy.
that we'll have an opportunity for everybody to concur by virtue of the vote that we're going to have on this measure. So all those in favor will say aye. Aye. Those opposed, no. Why don't we have a recorded vote on that that we can present to Mr. Sullivan?
Mr. Sessions?
Aye.
Ms. Fox?
Aye.
Mr. Bishop? Mr. Woodall? Mr. Nugent? Mr. Scott? Mr. Webster? Ms. Slaughter? Mr. McGovern? Mr. Hastings? Mr. Polis? Mr. Chairman?
Aye. Mr. Clerk, fourth total.
As 10 ayes and 0 nays.
10 ayes. So do we have 10 or aye? I mean, so Mr. Nugent.
It's 10.
Oh, right, okay. And the motion is agreed to, and Chair recognizes Mr. Scott. Sorry.
Recognize our friend Michael Hurston and his very attentive 8-year-old Kyle for being here today, paying very close attention to the disease, and hopefully not my level.
Right.
Mr.
And
Chairman.
He was
Mr. Chairman.
He was introduced earlier, and we're still happy to have you see you still charging away with us here in the Rules Committee. Mr. Hastings.
Chairman, I don't know whether we have the prerogative or you have the prerogative, but I was most sincere about our colleagues who are not here, Mr. Bishop and Mr. Nugent, and could we leave the record open to
I mean, I think what we'll do is we'll certainly welcome their ability to put statements in the record. One of the things that we do is so I think that's the way we'll deal with it. We'll allow members to put statements in the record. Now, let's proceed with Okay, without objection, the staff is authorized to make technically conforming changes to all matters ordered reported by the committee today, and the chair is authorized to make such motions as may be necessary to go to conference with the Senate on H.R. 2309 or other similar measures. So now we recognize the gentleman from Dallas for a motion.
Mr. Chairman, I move the committee grant H.R. 3309, the Federal Communications Commission's Process Reform Act of 2011, a structured rule. The rule provides 1 hour of general debate, equally divided and controlled by the chair, ranking minority member on the Committee on Energy and Commerce. Rule waives all points of order against consideration of the bill. Rule provides that the amendment, in the nature of a substitute recommended by the Committee on Energy and Commerce, now printed in the bill, shall be considered as the original text of the purpose of amendment and shall be considered as read. Rule waives all points of order against consideration of the amendment nature of substitute. The rule makes in order only those amendments printed in the Rules Committee report accompanying the resolution. Each such amendment may be offered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and opponent, shall not be subject to amendment, shall not be subject to a demand for division of the question. Rule waives all points of order against amendments printed in the report. The rule provides one motion we commit with or without instruction. Finally, rule provides that the Speaker may appoint members to perform the duties of the Chair for the duration of the period from March 29, 2012 through April 16, 2012, as through under Clause 8A of Rule 1.
You've heard the motion of the gentleman. Let me just say again that we have made in order all of the amendments that were submitted to the committee, 8 Democratic amendments, 2 Republican amendments, the one exception being the third amendment that Ms. Waters had offered, which we do believe, based on the report that we had, is duplicative with the issue amendment, the ranking member's amendment. And then the final item, the rule includes this section limiting the need for the Speaker to open pro forma sessions during the upcoming district work period. Are there any amendments?
Yes,
Ms. Slaughter.
I move that the committee give open rule to H.R. 3309.
You've heard the motion of the gentlewoman?
So that all members
Right.
heard about this important issue.
All those in favor of the Slaughter amendment will say aye. Those opposed, no.
No.
Pin the chair, the noes have it. The noes have it. The motion is not agreed to. Clerk, call the roll.
Mr. Sessions?
No.
Mr. Sessions votes no. Ms. Fox?
No.
Ms. Fox votes no. Mr. Bishop? Mr. Woodall? Mr. Woodall votes no. Mr. Nugent? Mr. Scott? Mr. Scott votes no. Mr. Webster? Mr. Webster votes no. Ms. Slaughter? Ms. Slaughter votes aye. Mr. McGovern? Mr. McGovern votes aye. Mr. Hastings? Mr. Hastings votes aye. Mr. Polis? Mr. Chairman?
No. And Mr. Clerk, the total?
3 yeas, 6 nays.
And the amendment is not agreed to. Are there further amendments? Mr. McGovern.
Mr. Chairman, I have an amendment to the rule. I move that the committee make an order and give the necessary waivers for the amendment by Ms. Waters, number 4, which would require disclosure of contributions to people lobbying the FCC whenever there is a possible conflict of interest. And again, our people are telling us that they're not duplicative, so to be safe, I think we should make this an order.
Okay. You've heard the motion of the gentleman. All those in favor of the McGovern amendment will vote aye. Those opposed, no. Paying the chair, the noes have it. The noes have it. Clerk, call the roll.
Mr. Sessions?
No.
Mr. Sessions votes no. Ms. Fox?
No.
Ms. Fox votes no. Mr. Bishop? Mr. Woodall? Mr. Woodall votes no. Mr. Nugent? Mr. Scott? Mr. Scott votes no. Mr. Webster? Mr. Webster votes no. Ms. Slaughter? Ms. Slaughter votes aye. Mr. McGovern? Mr. McGovern votes aye. Mr. Hastings? Mr. Hastings votes aye. Mr. Polis? Mr. Chairman?
No. Mr. Clerk, the total?
3 yeas, 6 nays.
And the amendment is not agreed to. There are further amendments. If not, the vote occurs on the motion of the gentleman from Dallas. Those in favor will say aye. Those opposed, no. Pay the chair, the ayes have it. The ayes have it. The motion is agreed to. And Mr. Webster will be managing this rule for the majority. And Mr. Hastings for the minority. And let me say we'll be meeting at 2:30 tomorrow afternoon. We're expecting a lot of testimony on different budget proposals that will be coming before us. So we'll look forward to seeing all of you then. Without objection, the committee stands adjourned.